practicing lawyer will not sit down here and allow. You don't sacrifice. You don't sacrifice justice on the altar of technicalities. And that was why the judges.
Okay, can we, gentlemen, if we can just.
My people, a lot is really happening in the political zone. Arise TV scatter in the early hour of today. Kasala boss in Arise TV as Tinubu lawyer and Bat.T.Le lawyer almost beat themselves in the early hour of today in a live show. Tinubu lawyer almost beat Bat.T.Le lawyer because of the tribunal judgment. And what you just finished watching is where the whole issue started from. But I would like guys to stay connected to the end of this video as I will show you the video of how everything goes. If you can share this video, ensure you share it, let it go viral, and you can share it, like it, give it a thumb up so that it will be recommended for us. So be there, stay connected. Coming back again.
Welcome you back to LAJUPOG TV.
I don't have bad news for you today.
The home of religious gossip.
But you should leave the fight for Mohammed.
What is happening in the Christendom? Join now to make sense with LAJUPOG.
Hello my great and wonderful viewers, welcome back to LAJUPOG TV. For those of you coming across this channel for the very first time, ensure you click the red subscription button appearing on your video screen, and don't forget, click the notification bell icon alongside so that whenever we drop a new video in few hours time, YouTube will easily let it know. Still on what is happening in the political zone. Kasala boss in Arise TV show today due to the tribunal judgment that the tribunal made some days ago. It's normally known that the tribunal made their ruling some days ago regarding the 2023 presidential election that was conducted on the 25th of February. Due to the outcome of the election, Obi took to court and he did not allow any obedient to enter straight to protest due to the presidential election result, because it is well believed that INEC did a lot of shenanigans in course of the election. INEC did a lot of things and they go against their own personal rule, and at the end of the day announced Tinubu as the president-elect, even with the shenanigans that APC people did, how they sent out talks in different polling units to bully people so as for them to have a higher vote than other political parties. When the tribunal made their ruling, even before the tribunal made their ruling, Obiden began to paste billboards of all eyes on the judiciary, because a lot of people did not believe in the judiciary, because Nigeria judiciary have been compromised and have been manipulated and is being controlled by a particular cabal in this country. So a lot of people did not believe in the judiciary. That is why they began to post all eyes on the judiciary billboards all across different regions in Abuja and even on social media. And at the end of the day, the judiciary eats the eyes of the obedient. And after the tribunal made their ruling, a lot of people have been talking about the ruling that the tribunal made. A lot of people have been going to different social medias and they have been going to different television stations talking about the judgment of the tribunal, because they said the 5 judges in the tribunal provide justice that day for them to come out to accuse their petitioner Peter Obi. They accused Peter Obi of sponsoring obedience on posting the billboards of the all eyes on the judiciary even before the tribunal made the ruling. They said Obi is the orchestrator of everything, all the billboards that obedient are posting. They said Obi orchestrated it. So they accused Peter Obi and they allege him in the court of law. I've never seen a situation where the judges are alleging their petitioner. In other countries that I know, the judge will always give credit to their petitioner. They will appreciate their petitioner for bringing the petition to court and not taking it to street to perform an unjust action and all of that. So this same issue caused a lot of trouble in Arise TV in the early hour of today. I would like us to share this video. If you can share this video, ensure you share to different social media platforms, and if you can share it, just like it, give the video a like, give it a thumb up so that YouTube will recommend it for us. Tinubu lawyer almost beat Bat.T.Le lawyer in Arise TV in the early hour of today due to the argument on the presidential election result. The argument breaks out and even Arise TV presenter and the interviewer cannot even hold them. You can see what the judgment of the tribunal is causing in Nigeria at the moment, and this issue is already sparking up a lot of reactions on the social media. So I would like guys to stay connected to the end of this video as I show you the video. Going back again.
Man has his own tendencies to disappoint, if you like, his frailty, and in this case, not wanting to stand by and for the truth, and interestingly, I hope that when the matter gets to the Supreme Court won't choose another number 6 to disappoint the people, because the issues are very lucid. They are fundamental issues, and in law we're taught as young students in law school that judges do not descend to the arena. They don't grant prayers you do not ask for. And let me say clearly that in one of those very funny paragraphs in the judgment, the judges came down to the arena, they did say about a certain witness from the Labour Party that she was a party member, the lady from Amazon, that they cannot admit her evidence because she's a member of the Labour Party. And then turns, on the other hand, to admit the evidence from a sitting senator, from a member, a reputable member of the APC, my brother and friend, who is presently the majority leader of the Senate, Bat.T.Le. That's, on the one hand, admitting that clearly, if you like, maybe it was the voice of Esau in the hands of Jacob, or vice versa. But let me say clearly, as I talked to you this morning, what is important is that, like we said before the judgment, all eyes were on the judiciary. It was the judiciary that was on trial. We have seen the certified true copy of that judgment, and clearly on the top of it, the header, I don't know why they made that mistake. The judgment, as it were, assumedly proceeded from the APC presidential legal team. And you could see when the judges were reading it, they were not reading a judgment that was indigenous to them. They were not reading a judgment that they could own. They were, if you're reading your speech, you make very little mistakes. But when you're reading a prepared speech, a written speech, of course you could see it. Everybody who watched that, the longest, if you like, the longest judgment we've seen in our historicity, would understand that it was clearly about the puppet and the puppeteer. But I believe that what we're doing, this forensic, is actually interested in putting our democracy right, because congruent with democratic process is the transparency and the credibility of the electoral process.
I would want to quickly address the issues raised by my friend and brother here, Chris Wokobia. As a practicing lawyer that have handled election petition matters since 2003, I will not sit down here and allow a fellow lawyer claim that a judge reading a judgment and with one or two corrections in court that judgment does not belong to him. I do not know if Chris had listened or handled matters where judges will read judgment for 5 hours. I have. I also know, as a lawyer that handles election petition matters, that election petitions are not dealt with on the basis of sentiment, but on the basis of pleadings. Also, I will also say this, that everything the Court of Appeal said on the 6th on Wednesday is not novel to me, and it's not novel to a lot of practitioners that have been involved in election petition. And like you rightly mentioned, the Court of Appeal and the Supreme Court in myriad of cases have said so much. So let us leave out sentiment from all of this and address as lawyers and look at the issues. Lastly, on the issues he raised, the courts, I've been reading the judgment, because even after listening to it, and I still take my time to read the entire gamut of the judgment, because what most lawyers do, they analyze judgment on the basis of newspaper reportage. We analyze judgment on the basis of law reporting. The court did not admit the testimony of the woman, not on the basis of the fact that she's a party member, but on the basis of the fact that she's coming as an expert witness that is coming to speak to a document that she did not produce as an expert. So let us quickly lay the issues, because I would also, if I expected him to even take me to the area where the court specifically mentioned her because she's a party member. That said, election petition, why has the court not been able to upturn presidential election petition? Presidential election petition, the election petition generally, like we say, are sui generis, and your petition will rise and fall with your pleadings. There are also, with the restrictions of 180 days and the new amendment to the Electoral Act, Amendment of petitions are no longer allowed, and it is also sacrosanct that petitions must be filed with witness deposition. Once a petition is filed and witness deposition are subsequently front-loaded, be rest assured that those witness deposition will be discountenanced in the course of the hearing. Also, because of the requirement for presumption of regularity in favor of INEC once results are announced, as clearly stated in the Evidence Act, once you, just like section 36.5 of the 1999 Constitution, the onus is now on he who asserts to prove that indeed this presumption should be shifted. And how do you prove? It must be through witnesses that were present at the polling unit, not people who were told what happened at the polling unit. And also it must be through documents that were handed over to you at the polling unit. You are bound by time. Why file a petition knowing fully whether you cannot amend? Why file a petition and now wait for INEC to give you documents that you will now in turn file later, knowing fully well that the same document will be discountenanced at the trial? So I think the law, the requirement of the law on proof is so high that it is difficult to disprove between the specific time. That's why you have all of those challenges.
In law, my brothers just talked about how one of the most profound election petition lawyer in this country is a lawyer that represented the Labour Party, and then Chris Uche. So we have different sides to these issues, but let me say clearly here that the questions I'll put here. One, if you talk about the proof, the presumption of regularity in favor of INEC, what did INEC say before the elections, and what did he do during the elections, and what happened, what the justices, because if you followed the entire ruling, you find out first that at every point in dismissing the issues put before the court, the justices descended to the arena. They sounded like litigants. They sounded like they were defending the position of the All Progressive Congress. And I say, you saw the issue about 25% of Abuja. Rather than staying on the provisions of Section 134 and Section 299, they were simply pondering around the issues. By law, the Constitution provides a special status for Abuja. They threw it away. Regarding issues about, and I'm saying this without fear of querulous criticism, regarding issues about forfeiture, interestingly, that's why I said maybe metaphysically, the justices of the Court of Appeal were meant to make the mistakes like human beings, because the Supreme Court were going to face the Chief Justice of the Federation, who had, in a previous ruling in 2014, 2007, and 2014, admitted that forfeiture is a penalty for a crime, and then if it's in the event of a civil offense, it, according to the Constitution of the Federal Republic of Nigeria, can pass to vitiate the candidacy of anybody seeking the office of president. They didn't address the fundamental issues there. They just pondered around it. And then what about the issues of double nomination? For a judge to say that Shetima's was inadvertent, that his double nomination was not deliberate, that was coming to descend into the arena. Everything about that judgment, everything, and that's exactly why the candidate of the PDP said in no uncertain terms that what we had on the 6th of September was judgment, not justice. And then the candidate of the Labour Party said in no uncertain terms that we're going to the Supreme Court to address these fundamental issues. You don't sit down and say that because nobody has been removed by the court of law in a presidential petition. That it cannot happen. What we're talking about is justice. What we're talking about is doing what is proper, right, and right. I do not think that insisting that the law should be followed strictly is pandering to emotions or sentiments.
All right,
the law is the law, and if you must follow the law, do so and interpret the Constitution and the Electoral Act. You don't do a 12 hours judgment ruling that is basically pandering to the whims and the caprices of the ruling party. You don't do that.
I would like to come in, so sorry, Aaron, I would like to come in here because, fine, we've spoken about the judgment, but I also want to talk about the blunders because we have 21 days, of course, for them to refile and go to the Supreme Court with the same evidence and with, what the judges were able to look at during this presidential election tribunal. And the court noted procedural blunders by the petitioners' legal teams, including failure to file witness statements on oath as required. The court also highlighted paragraphs of the petitions that were deemed vague and imprecise or generic. They also emphasized the lack of credible evidence presented by the petitioners and seeing how these errors impacted the outcome of the case. We're looking at the back end where some senior lawyers have said that the justices did a thorough job to the extent that the representing parties were chided even while the judgment was being read for the inadequacies in their research to build their clients' cases. Now, are we looking at a situation where the opposition's petition was watery from the beginning because what the judgment was based on the facts that they were able to look at? And if they're using that same, those same witnesses and that same, all of that, taking that to the Supreme Court.
You don't sacrifice justice on the altar of technicalities, Shaito. You don't sacrifice. You don't sacrifice justice on the altar of technicalities, Shaito. And that was why the judges.
Okay, can we, gentlemen, if we can just take it one point at a time. All right, then let's go to Libros.
Yeah. So let me first and foremost say that my friend and brother here is not talking law but sentiment, really. With all due respect to him. The judges, thank God everybody listened to those judgments. For the discerning, like you have rightly identified, the judges pointed at, how do you read judgment? You will read the argument in the body of the pleadings, the facts in the body of the pleadings. You will bring out the argument in support of those pleadings. Then you read the pleadings contradicting those averments in the petition, that's the averment of the respondent, and then you read also the argument in support, and then you draw a conclusion as laid down by the laws, not sentiment. So what we have here is a situation where, first and foremost, you say the lawyers that handle the matter, yes, we agree they are seasoned lawyers. The lawyers for the respondent also are seasoned lawyers. Lawyers, no matter how seasoned, one person must, at the end of the day, will win. So in this case, what transpired? What happened? Let's look at the averment one after the other, because I want to discuss law. I don't want to discuss sentiment. I don't want to talk about morals. You allege that you have agents in 170-something thousand polling units. You couldn't produce one to disprove or to prove the evidence that truly there were irregularity in at least one polling unit. On the issue of 25%, in 2005, the Court of Appeal and the Supreme Court in Obasanjo, if not for time, I would go straight to the dictum of the Kitobi GSC. If you permit me, I can read it for you. Held that there are no special status in as far as votes are concerned. and that all votes are equal. The Court of Appeal on Wednesday simply followed that dictum that had been laid down. And Section 299 of the Constitution also states that for the purpose of this Constitution, FCT shall be taken as a state. Allow me, please. And so, what the court simply did was to reiterate the position that had been stated by law. And so, if you are going to counter those positions, you must cite a superior law and not come here and pander to sentiment
at this point
and begin
in time,
to call
before we come to Mr.
and those judgments were written.
Permit me to interject at this point, because if you're speaking about the law, people were a little bit perplexed and puzzled in regards to the five-man panel led by Justice Imani and sections 52 and 65 of the Electoral Act, which granted INEC the freedom to prescribe the method of transmitting result. And you and I know there is no secret. There are video evidences everywhere where INEC vowed and insisted that electronic transmission of result is the only way out, and they decided to renege on their promises.
Okay. So quickly, please, because I wanted to address that area.
Okay.
When a provision of the law gives a discretion, and somebody says, I am going to do it this way, on the day of that election, that same person comes to say, for the reason of force majeure, I can no longer do it that way. I will do it this other way. What the court would do, the court cannot take away that discretion, because it is not a discretion donated by the court, but by the law. And what the court simply said is this unanimously. Both the Supreme Court has said this, the Federal High Court has said this, the Court of Appeal has said this repeatedly. What the court simply said is INEC has the discretion. The word didn't say shall. They said as stated by INEC. So if INEC gave a regulation and they are not able to comply with that regulation, does the law permit them that discretion? The answer is yes. That is what the law simply said. And then lastly on this, do you know that the same issue that we are talking about now, the Supreme Court, in the case of Osun, when the Supreme Court delivered judgment, those that are complaining today, we are celebrating. On the same IREV, the Supreme Court, not Court of Appeal now, the Supreme Court said that INEC has a discretion. The PDP celebrated it and they said it was victory for democracy. APC complained that it shouldn't be. But today, it is in favor of APC. The same PDP that celebrated before are complaining. The APC that were complaining before are today celebrating. That is the law. It does not pander to sentiment.
Let me say very importantly that my brother here talked about the status of Abuja. Section 299. Section 299 on the status of Abuja talks about Abuja.
We are not really
presumed. Can I just talks about Abuja clearly being presumed as a state on 3 accounts, not with respect to elections. Every state has its provision regarding elections, please. Every state has its provision regarding elections, and you do not lump Abuja. Abuja does not have 3 senators. Abuja has 1 senator. Abuja does not have a governor. Abuja has a minister over Abuja. Abuja does not have a state cabinet. Abuja has a development authority. Abuja by the constitution is unique and special, and those who live in Abuja are not necessarily settlers. You have indigents and you have people from different places. So for those who, if you read, listen, I'm talking, I let you talk. The fundamental issues is that when people decide, and it was Sir Walter Scott who said, oh, what a tangled web we weave when first we practice to deceive. When we look at these issues, you don't sacrifice justice on the altar of technicalities. And that's the fundamental argument that I'm making here. If you wake up and tell me that regarding forfeiture, for instance, the president, CJN of the country, had ruled, and why didn't the court mention that ruling where he admitted in that case, Mohammed Abacha against the Federal Republic of Nigeria, he talked about forfeiture clearly as a punitive, as a punishment for an offense, or even in civil matters. Our Constitution in Section 137, subsection 1, talks about when you have forfeiture, either for criminal or civil offense, you lack the constitutional right to run for the office of president.
Thank you for staying connected, my great and wonderful viewers. You can see the argument that was going on in Laju TV in the early hour of today. You can see what is going on due to the judgment that the judges passed in the tribunal. You know, all these judges, they are under the influence of something. Someone is influencing them. The judgment they made, according to report, though I wasn't in the court, but people that were present in the court that day, they came out and they made the statement, they made it to the general public that the judges read the judgment as if they are not the orchestrator, they are not the one that writes the judgment. They read it as if it is not from them, because they made a lot of error, they made a lot of grammatical error in course of the reading. And mind you, when you are reading something and the thing is from you, when you are reading something and this is your English in place, there's a way you read it and you will avoid a lot of errors because it's coming from you. But in the case of the judges in the tribunal that day, in the day that they making the tribunal ruling, it wasn't like that. It was as if they gave it to them to read. And mind you, the judgment is carrying the inscription of Tinubu legal team on top of the paper. That's to tell you that Tinubu team, Tinubu lawyers are the one that is orchestrating the judgment in that very day. So they orchestrated the judgment. So that judgment that they passed is not from the judges directly. And another thing that will open your eyes to is the fact that before the judgment, before the tribunal made their ruling, the news spread out that they started sharing money in the tribunal. And how do we get to know this? A judge, we have 5 judges in the tribunal that made the ruling. So 4 of them were men and only 1 is a female. So the woman among them cried out to the social media. She shouted out, she said she did not want to collect any bribe from anybody, that the money they're sharing right now, that they should not bring it to her table, that she's not interested in the money, that she's contented with what God has given her and her family, that she's okay with what God has given them in her family. That shows that for that woman to cry out, she's not the only judge. We have 5 judges and she's just one of the 5 judges. That shows that the other 4 judges, if you should look at this scenario very well, make your observation, the other 4 judges, they will also tender the money to their table. For them not to cry out, that shows that they welcome the money wholeheartedly. And we can see the result on the judgment that they make in the day that the tribunal were making their judgment. It is normally news that the 5 judges, they were very harsh to Peter Obi. I've never seen a situation where judges are harsh to their petitioner. Other countries that I've been seeing is that the judges will always credit their petitioner and they will appreciate their petitioner because their petitioner respect the law and the constitution for bringing the petition to court and not taking it to the street for protest and all of that. Obi wanted to protest when they released the presidential election result, where INEC announced Tinubu as the president-elect with everything that happened with the election. So Obi wanted to come out to street, but it was this same Peter Obi that the judges are accusing and criticizing and downgrading in the court of law. It is this same Peter Obi that stopped all obedient. He said they believe in the judiciary, though all obedient, or let me say 90% of obedient, they don't believe in the judiciary. But Peter Obi trying to confuse them, and they stepped down, they didn't protest. And that same Peter Obi now is being accused in the court of law for orchestrating the billboard of all eyes on the judiciary, because the judges said that it sounds as a bullying to them and a sense of disrespect to them. Maybe that is why they are harsh to obedient in the court of law, and that is why they harsh to Peter Obi precisely, including Article 2. But that of Peter Obi is obvious, as if they fought before or they have an argument before coming to the law court. They said the evidences that Peter Obi have against the petition they filed against Tinubu, Shettima and INEC as a whole, they said the petition is not having a concrete evidence, that the petitions are having watering evidences. And what is watering evidence in this whole issue? They said the video evidences that Peter Obi provided in course of the election, where thugs were bullying people in different polling units and different things that happened in the election, and even the petition that Peter Obi filed against Shettima for pursuing 2 political positions, and even Tinubu, Chicago State University, and all of that. They said Peter Obi is not having a concrete evidence. They said these evidences are watering, and they even accused the same Peter Obi of manipulating the evidences that he brought to the law court. And I've not seen a situation where Obi manipulate any evidence that he took to the law court. So we saw everything that happened in course of the tribunal ruling, the shenanigans that happened, and it is no more the news that it was Tinubu legal team that orchestrated the judgment that the tribunal judges read out that day, because their judgment document is bringing out the inscription Tinubu legal team. That's to satisfy that Tinubu legal team are responsible for the judgment of the day. And lastly, we see what Peter, the lawyer, pointed the attention of the people to. He said in the video that I just finished watching from Laju TV, he said an Amazon expert came as a witness to the law court, and when they were trying to present the Amazon expert to come and showcase the evidence they have against INEC and all of that in course of the election, because INEC is believed that they bought the Beavers machine that they said they have issue from Amazon. So when Labour Party lawyers wanted to tender an Amazon expert, the judges declined. They said the Amazon expert is a bona fide member of the Labour Party. So they said someone that is from Labour Party cannot stand as a witness for them. But when it gets to the turn of APC, a senator in APC, a bona fide and certified senator in APC, stand as a witness, and the judges accepted him. So what do you guys think? And you see the shenanigans that happened in the court of law? Drop up in the comment section of this video. I'm gonna let them for you. Ensure you follow me on all my social media handles on Facebook at LAJUPOG TV and LAJUPOG Entertainment, and on Instagram at LAJUPOG. Also follow us on X at LAJUPOG, and we're also on TikTok at the moment. So follow us on TikTok at LAJUPOG to receive back-to-back updates regarding what is happening in the political zone. Guess what, guys? See you in my next video. Bye.
I see the hot for my body, I say make I yarn you. Religious gossip plenty day for body. Pastor with the line on top, be pastor. For LAJUPOG Watch TV. Pastor with the back, where politician with the do pass himself. Corrupt leader, why you with the for church? All as LAJUPOG.